Good morning, good afternoon, everyone. Thanks for joining us today. We're of all the webinars and topics that we've done related to COVID in the last, now 9 months. I'm actually excited about this one. I think that there's a lot of good information that we're going to unpack here in the next hour. That a lot of it's common sense. Some of it is new breaking developments and updates related to COVID-19 and employer liability and reducing those liabilities. Of course, today's discussion has an eye specifically on work comp claims, but it deserves a broader discussion. How do we protect employers? How do we protect businesses and organizations from litigation and from risks related to work comp and your employees, or even beyond work comp related to customers, third parties, the public? There's a lot to unpack. And my colleague, Jack Sanker, he's the OSHA work comp person for today's webinar. He's alongside me for this ride. I'm Jeff Risch. I'm a traditional labor and employment attorney at SmithAmundsen. And if you haven't, just as an introduction, if you have not looked at or reviewed our COVID Resource Center, you might want to check that out. It's right on our webpage at salawus.com. If you're not familiar with Matt Horn, at SmithAmundsen, Matt Horn heads up our OSHA group. In fact, he's got a pretty cool website at oshalegal.com. And if you need to know more about the latest and greatest from OSHA, specific to OSHA, that page and that site has a wealth of information and updates relating to OSHA. And of course, if you don't subscribe to our L&E blog, you might want to do it at laborandemploymentlawupdate.com. It's trying to provide our clients and contacts with the latest and greatest labor and employment developments on a local level, regional level, and national level. So with that in mind, let's just jump into it. Bottom line, what's the theme for today? Trying to protect you, trying to protect all of you, trying to emphasize that these rules, these guidelines, these safety and health standards that are developing in real time on a local level, on a state level, from the CDC, from OSHA. This isn't optional. This stuff isn't optional. We've got to identify and do what we can. And then some of it's related to our industry. Some of it's related to where we are located in the type of organization, company, business that we're in. But the general mandates, guidelines and standards, whether it's unique to our industry or just not unique to our industry, all employers need to keep them in mind. We have to identify those and continue to do the best we can to strictly follow and adhere to it. Because if something bad happens, if the finger pointing against you and your organization, your business, is being done a month from now, 6 months from now, heck, years from now, you want to look back on what you've done and what you continue to do, and adopt these best practices. And these best practices have to, at a minimum, adhere to the latest and greatest guidelines, mandates, standards on a local level, a state level, and that's typically the Department of Health, as well as the CDC and OSHA. and creating and preserving a written record. You remember when people scrapbook? Remember the scrapbooks? My wife did scrapbooking. My mom did. Who didn't do scrapbooking? I wasn't really into it, but I got the concept. And it's sort of, I look at this sort of like those scrapbooks back in the day. I don't know, some people might still do scrapbooking. And nothing against scrapbooking. But with this, with the theme of what are we doing from a safety and health standpoint, I think it's absolutely imperative that we have a well-documented record, a scrapbook, if you will, of what were you doing in March, April, May, June, July, August, September, October, November, December, into 2021 with an eye on adopting the latest and greatest. What you did in March to stop the spread, to protect your workers, is going to be, it has to be, a little different than what you're implementing and what you're doing today in December of 2020. And it very well is going to evolve and change as we go forward. The I is to reduce litigation risks and claims. So the checklist, sort of a checklist, you get, again, stay current with the guidance and best practices, and maintain a plan, maintain a COVID-19 plan. It doesn't have to be 100 pages. It doesn't have to be 50 pages. It doesn't necessarily have to be 10 pages, but some plan, some plan that evolves and incorporate that latest and greatest guidance and mandates coming from the government. How are we educating and communicating the plan and informing our employees of new policies and practices and procedures? How are we doing it? Is it a daily email? That could be a little nauseating. Is it weekly? Well, yeah, okay, weekly. Is it when necessary? Whether that's weekly, monthly, daily? It's probably the latter. When it's necessary, when new policies and practices and procedures need to be developed, are being developed, yeah, we need to communicate those in real time to our employees. And we're communicating the plan, we're publishing the plan, we're proud of the plan, we're confident of the plan. And then we're dressing up our workplace, our offices, our facilities, our plants, our campuses with the signage, not only for our employees, but for our guests, for third parties, for the public. I've entered workplaces over the last 9 months. I've been around, and there are some a lot of workplaces. Most of the workplaces I've entered, when I enter that workplace, I feel like this is the cleanest it's ever been. I feel confident. I feel secure. I feel safe. Some of the workplaces, most of the workplaces that I've visited over the last 9 months, they really have an eye on that. You know, it's not window dressing. It's beyond that. It's real. It's meaningful. But the signage, the posters, the plans in place, even the little arrows on the ground, right, and the spacing on the ground, and it makes you feel good. It makes you feel safe. That matters. Believe it or not, it matters. It matters for your employees. It matters for your guests. It matters. Reinforce the plan and policies. Do reminders. Whether it's through some sort of online system or even in an email, make sure that employees are reminded of the latest and greatest. Maybe have a company-wide conference call or a company-wide webinar of sorts to remind people every now and then of what the latest and greatest is. Document your steps. Document it in written form. Investigate all employee COVID cases. We're going to try to identify how the employee contracted the COVID-19. We're working and cooperating with local Department of Health. That's not optional, it's required. We've developed a questionnaire and HR checklist to help you investigate COVID-19 cases and perhaps a cause or maybe varying causes of how somebody may have contracted COVID-19. I'm going to save that to the end. If you've heard me before talk about COVID-19 and reducing risk in litigation, you've heard me talk about the questionnaire. I am going to include the questionnaire at the end of today's webinars, just as a friendly reminder. And then we're going to also review insurance policies. Review your insurance. What insurance do you have? Whether it's again, work comp is work comp, but from a general liability standpoint, what do we have from a business interruption standpoint? Having those discussions with your attorney, with your broker, with professionals, with business partners, with an eye on that is very important, particularly with third-party claims. What's the threat? Well, with regard to work comp, I think the biggest threat there's two threats. You've got a work comp threat and you've got the plaintiff's bar. The plaintiff's lawyers, they got to eat. They've got to eat. They've got to make a living. And so as we see the plaintiff's bar becoming more novel in their theories of liability, going after, quote unquote, the deep pocket employer, a business, an organization, likely with some insurance coverage in place. And Jack's gonna hit on that later on in this hour. That is also evolving from a third party general liability perspective. But from a work comp perspective, we're seeing, right? We're already seeing states moving towards an aggressive presumption that a COVID-19 positive worker presumed to have contracted that virus in the course of their employment. Now, the presumption is not irrebuttable. But we see states like Illinois, California, believe Minnesota, other states creating a presumption, not just for emergency responders in healthcare workers, but general industry or essential employees. And if you look at it, in most states, essential employees are covering pretty much everyone working at an employer. You know, the essential businesses is pretty broad and broadly construed. So we're seeing states take an aggressive legislative stance and move to protect the employee, right or wrong, to protect the employee in a more aggressive way. And so with that presumption that a COVID-19 positive worker contracted the virus in the course of their employment, employers have to be ready to defend those claims. And just, you know, I'm not going to go through the California outbreak presumption, but I think it's newsworthy and it's noteworthy that the California Senate Bill 1159 worked its way through the legislature out there in Sacramento and was signed into law. And talk about a real aggressive novel approach, not only to create a rebuttable presumption for work comp purposes when somebody tests positive, but also requiring certain self-disclosure and reporting directly to the state of California when outbreaks are happening at a business. And so this presumption that the individual contracts the virus at work through the course of employment is very, it's if the presumption is there, again, it's not irrebuttable, but it definitely changes the game, so to speak, from a defense position. What's the goal for today? What are we trying to do specific with regard to employment and work comp, or just general liability beyond our own workforce, customers, and third parties? Generally, whether it's work comp or third-party liability claims, we want to be in a good legal position. We want to be in a position where we're confident. We've got facts. We've got evidence. We've got a good basis to say you did not get COVID-19 at our workplace. You didn't get COVID-19 in the course of your employment. Hey, folks, I'm a defense lawyer. My mind is on defense, defending employers, defending businesses. I'm not an employee advocate. That's the disclaimer. The main crux of today's webinar is to protect the employer. So I'm trying to Jack and I are coming up with how do we put our clients, put employers, put businesses, organizations, employing people, or doing business with the public and third parties and customers in the best legal position possible to defend when it's appropriate to defend. Of course, people can and do contract COVID-19 in the course of their employment, and those very well are valid claims. The facts will dictate whether a claim is valid or not valid. In my world, I'm trying to make sure that if the individual did not contract it in the workplace, or by utilizing your services or your products, employer, as a customer or a third party, that you are all in the best position to defend. Because it's not stopping anyone from making the accusation. If the individual is not in your workplace for 14 days prior to contracting COVID-19, I'm feeling pretty good. And we need to freeze that fact. If the employer complies, I think this is the most critical. You comply with the local, state, and CDC guidance, the latest, the greatest. You're protecting your workers, your customers, third parties, as best you possibly can. Because that goes to that third element. The individual was more likely than not exposed to COVID-19 through another source or cause. And sort of if I'm doing everything, if I've got clients that are doing everything they can and are putting their best foot forward on the compliance and adhering to the guidance, I'm feeling really confident in the individual being exposed outside from another source or cause. So with that, we've got to segue, because OSHA, I think the OSHA standard's important, and I want to turn it over to my colleague, Jack, to talk a little bit about OSHA.
Thanks, Jeff. So the risk managers, safety personnel, and everyone else in the audience that deals with OSHA knows the general duty clause probably inside and out. And that's a good place for us to start, because up until recently, OSHA really didn't have many specific COVID rules. And we'll get into that later. But the catch-all provision of the general duties clause would and does apply to many of the scenarios where a COVID exposure or something else could result in a claim, or perhaps an OSHA citation once OSHA gets up and running again, which again we'll talk about in a minute. So, for those who don't know, the general duty clause requires an employer to furnish to its employees a place of employment which is free from recognized hazards that are causing or are likely to cause death or serious physical harm. So right now, we're speculating, but there's credible reporting on this. A lot of folks tend to think that the Biden administration will issue an emergency order from OSHA, which will address some of this stuff more specifically. What that order looks like, we're not quite sure yet. It might take some elements of the California provision that Jeff just spoke about. It may do a couple of other things. But we are fairly sure that the administration is going to do something else. The OSHA is an executive agency, so President Biden could do this with the stroke of a pen, doesn't have to deal with Congress. Let's see. OSHA does divide businesses for COVID into categories of sort of low risk, high risk. Most employers, even if their employees are essential employees, most of those jobs are going to be considered low risk. The ones that would be high risk would be first responders and healthcare providers, things like that, folks that are going to be in direct contact with or likely to be in direct contact with exposure scenarios. Right now, OSHA doesn't have additional PPE requirements, but any state, local government probably by this point in December of 2020, at this point probably does. So remember that OSHA oftentimes sets a baseline expectation for the conduct of employers, and that state and local governments may add additional responsibilities on top of that. So be cognizant of your local responsibilities as well. OSHA does have new reporting requirements for COVID-19 cases in certain circumstances. Generally, you're going to have to report a confirmed case of COVID. If the case is work-related, and if the case involves one or more of the general recording or reporting criteria, which is the stuff that's already been in place, such as medical treatment beyond first aid, if someone's been at work for X amount of days, if there's a hospitalization, obviously a death case. You would have to report an injury in those situations anyways. If it's a COVID-related injury, then of course you're going to have to report it anyways. For it to be a work-related exposure event, the employee has to be infected at work or while working, and those are two distinctions that we can get into a little bit later. If the employee contracts the disease out of work, obviously it's not going to be the fault of the employer. Proving where someone was infected is, you can imagine, going to be very difficult for either side. From the employer's perspective, to prove that this person was not infected at the workplace, you're trying to prove a negative, and you would do that circumstantially, as Jeff had alluded to earlier, showing that the employer is compliant with all of the specific rules that are in place, the federal, state, and local levels, showing that there has not been a similar outbreak among different employees, showing that the workplace is clean and safe, and all those things. It's circumstantial evidence that the infection did not take place in the workplace. So let's see. There is new guidance that has recently been promulgated by OSHA. OSHA does require employers to make a reasonable determination as to whether a confirmed COVID case was contracted at work. Specifically, OSHA is going to require employees now to interview their employees, or employers to interview their employees, question them as how they believe they were contracted, how they were infected with the disease, discuss with their employee their out-of-work activities that may have resulted in the exposure, and of course, review the work environment for the potential exposure itself. If, in the context of these types of interviews, it becomes apparent that the infection happened at the workplace, at that point, the reporting requirements for OSHA would have to come into play. We'll talk briefly about kind of the current state of things at OSHA, and generally not great. OSHA is, they've been receiving calls and things like this, reports for the past 9 months. OSHA employees have by and large been working remotely. A lot of them are working from home. OSHA's kind of been operating in a limited capacity more or less since the outbreak. They're not doing spot inspections. They're not coming into the workplace and doing the things that you would normally expect OSHA to do. So one of the things that we're speculating on is that there's going to be a backlog of those things once enough of the population is vaccinated. OSHA may have to go through this backlog of reports and inspections and whatnot. But as it stands, OSHA's been pretty dormant during this, by and large, because of the same reason that everyone else is working from home. So right now, there may not be inspections, but in the near future, there may be a lot of them. There were new rules promulgated on November 30th, which we could see happening at the federal level. These are required COVID prevention and training programs, which required social distancing, updated required PPE requirements, and reporting requirements that are going to be sorted into different categories in non-outbreak scenarios, outbreak situations, and what's called major outbreaks. Major outbreaks are defined when there's 20 or more cases within a 30-day period, at which point additional measures are going to be triggered. In what's called a regular outbreak, the employer is going to have to conduct its own COVID-19 testing at no cost to the employees, and there's requirements as to how frequent those tests have to be repeated in the work zone before an employee can be cleared. Non-outbreak situations, employers have to notify their employees about exposures, about positive tests while preserving personal identifying information, and that's a sort of a HIPAA concern. Basically, if one of your employees is infected, employers are going to have an obligation to tell the other employees about the infection without revealing who it was specifically that was infected. There's also going to be additional requirements for employers to maintain record keeping and reporting for the local health department as well as to OSHA.
So Jack, this is the California, right? I don't. You might have mentioned it, but it might have cut off. This is what California did, and so what we're trying to, the crystal balls, which can be dangerous. Is this a prelude to what may come on a state level or even a federal level under Biden, a Biden administration? We know, all the chatter that I'm hearing from Washington related to the first 100 days is a lot of it is surrounding an emergency rule directly related to COVID, perhaps the day he's inaugurated. I mean, like first thing out of the gate, some sort of an executive order or and certainly trying to work with the OSHA to put in place and put into action some emergency rule related to COVID. I don't think that it's going to be exactly like what California has done, which is the information on this slide is just an ounce of, it's a drop in the ocean as to all of the burdens and regulation that's placed on an employer out there with non-outbreak situations, outbreak situations, and what they call major outbreak situations. But I could easily see the federal government trying to, take a page out of this. Out of the California playbook on some material level going forward. So, with all that in mind and what Jack went over related to OSHA, I think a lot. I think where the rubber meets the road is if I'm doing what I'm supposed to be doing under the OSHA standards, if I'm asking those questions, just going back to the questions that OSHA wants you to ask, how they may have contracted it, their work activities, the work environment, has there been an outbreak, on the employee's line, department, shift, all of those relevant questions, those meaningful questions. I want, if the facts, well, the facts are going to dictate whatever the facts dictate. But if the facts dictate that employee did not contract COVID-19, I'm using that. I'm using what I'm supposed to be doing under OSHA as part of my defense related to work comp or to any other third-party claim. And speaking of third parties and employees, if we're following the latest and greatest from a CDC guidance, and they update it every now and then, I'm feeling really confident. I'm feeling more confident. The CDC, I'm not going to go through all of these CDC, the guidelines. You can, I've included a link on how businesses can respond and to slow the spread and reduce the transmission of COVID at their workplace. I also include the mitigation. We include quick links to mitigation activities and things that you should have in mind to reduce that spread. And I think there's valuable information through the CDC links and guidance. Ultimately, you're going to have to come up with a plan. You should have a plan and train on the plan. And it's important, I think, as we go forward, that we've got some sort of daily evaluation of workers, whether it's a temperature check or at least an inquiry into any fever, documenting that employees are entering your walls, your brick and mortar walls, if they are coming into a facility or a plant, that they don't have symptoms, that they have not been exposed. From what I've experienced so far in the last 9 months, from what I'm hearing from an OSHA level, from a Department of Public Health level, from governors and different executive orders, there needs to be some daily checkup with the employees entering a physical office. Now, some employers, because of their industry, because of what they do, because of employees shoulder to shoulder on a production line, particularly in food processing plants, they are doing actual daily checks, physical checkups, a temperature screening and a short inquiry. You're okay? Come on in. If you're not okay, you got to go home. At the very least, I'm seeing employers adopt we assume that you do not have these symptoms. And so as you log in for the day, as you show up for the day, there's at least a posting, some sort of reminder that pops up on your computer screen. If you have these, you need to check these symptoms. You need to check yourself for these symptoms. If you have any of these symptoms, you need to go home. You need to contact your medical provider, and you need to contact so-and-so in HR or in the office. So elements of a plan, having that some sort of daily reminder or check in place is important. Of course, the obvious, and I'm not going to just write, the list is the list, and for time's sake, I'm not going to go through all these points that you're probably already intimately familiar with. Understand that your plans, what you're doing, more importantly, what you're not doing, or maybe not documenting well, the unions, local government, state attorney general's office, public health department, they're going to be looking at your plans, what you have in place or what you don't have in place. And so you can create exposure and liability for having no plan or a poorly executed plan, or a plan that's, it has a lot of dust on it and you haven't dusted it off since March or April. So Jack, talk a little bit more about the work comp liability generally, and particularly how that all works.
We'll start with a bit of a refresher on this. For those of you who don't deal with work comp stuff directly, workers' compensation is a system by which the employer can become liable to their employee for a certain category of damages. Typically, it comes in the form of lost wages, payments for medical bills, things like that, and compensation for any type of permanent disability that may result from a workplace accident. Each of those things is made up of a number of different elements that we would have to spend weeks talking about if we were to get through. So we'll try to cram through the gist of it right now. But generally, for a workers' comp claim to be compensable, and by that we mean for a claim to for the employee to have a valid claim, the worker had to have been injured during the course and scope of their employment. Which means in this case, they will have had to have contracted a harmful illness. They will have to have been infected by COVID-19 while working and in the workplace in order for that employee to have a workers' comp claim. Let's see here. Generally speaking, what courts are going to be worried about for COVID-19 claims is whether the occupation presented an increased risk or a greater likelihood of contracting the condition compared to the risk that the general public has. And this is important because this is where a lot of these presumption rules come into play, like the California rule. There was a rule in Illinois that had the same effect. An employee is only going to have a work comp claim if their accident was as a result of them being subject to an increased risk of injury compared to the general public. And generally what that means is activities that you would be doing anyways outside of your workplace are not going to be compensable if you're injured doing them. A good example would be standing or walking. If you're on the job and you're just walking down the hallway and you trip over your own feet and fall, yes, that's a work injury. You were hurt at work. However, the activity of walking down the hallway is not an inherently riskier activity than it would be if you were doing it outside of work. So that employee does not have a valid claim. What happens in workers' compensation with respect to the COVID-19 claims is that they usually are coming from employers that are exempt from the stay-at-home orders. They're essential employees, folks that are defined by different state rules as essential, which means they're going to be allowed to go to work while everyone else is not, or they're going to be allowed to go out into the world, potentially contract an infection while other people are supposed to stay at home, which leads to many of these, or which can help the employee in their claims, in their workers' comp claims, because, look, they can make the argument that I'm not allowed to go out to the stores. I'm not allowed to go to restaurants or anything else. The only place I was allowed to go was to work. Therefore, if I got sick, it happened in the workplace. And that's kind of what we're seeing with these claims as they're being filed. The important issue, and you always want to highlight in any workers' comp claims, whether it's a back injury, a knee injury, but in this, COVID-related stuff, is that causation is key. Even if there are legislative presumptions in place, the employee still, at the end of the day, has the burden of proving that they contracted this disease in the workplace or while working. And so, which is going to be difficult, although plaintiffs' lawyers get creative with this stuff, as we know. Likewise, the inverse is true for the employer. Employers have to show that there are other plausible ways in which the employee may have been infected. So you would get into the interview process or investigatory process, try to figure out what this employee may have been up to over the past 2 weeks. If the employee had attended, if you could figure out from their social media, for example, that they attended a party when they weren't supposed to, that's an infection point, right? They could have gotten infected there. Or if they, were regularly breaking the rules related to shelter in place or whatever other state orders are in place. Each of those creates an infection vector that makes it a plausible infection point that's, not the workplace. So investigating, what the employee has been up to for the past couple of weeks is going to be a key part of defending these claims. Let's see. Jeff, you could switch to the next one. And so one of the things that you're really going to be looking for as an employer in these situations facing a COVID workers' comp claim is employee carelessness. And if the employee carelessness outside of the workplace, I should say. If the employee is breaking the rules and everything else, then you're going to have strong defenses and being able to point to all these different points in time in which the employee may have contracted COVID that were not in the workplace. However, courts are not sympathetic to the idea that employees who did contract it in the workplace are responsible for that. So employee carelessness in the workplace is not really going to be a strong defense. So for example, if you were to argue that an employee, wasn't washing his hands enough while he was on the job, and yeah, he got COVID while working, but it's because he didn't wash his hands enough, that's not going to get you very far in our experience. That is going to be viewed as a systems breakdown on behalf of the employer, typically. If the employee is not washing his hands enough, that falls on the employer for not having a system in place to ensure that he or she.
Jack, if the employer is not enforcing the mask rules or the social distancing rules, that's on the employer.
Certainly, right. So you're not going to get very far by, if it comes to be shown that the employee did contract COVID in the workplace by blaming the employee. Courts typically are siding with the employee when they argue that it was the employer's fault in that situation.
Mm-hmm.
So, as I mentioned, the key issues here are going to be the fact investigation by the employers, looking at what the employee's been up to over the past couple of weeks, and finding other plausible infection points for which you can argue that this is where the infection came from.
Yeah. And Jack, on the we'll get to the questionnaire at the end, and I'll run through that, and I'll make sure everybody on the webinar can go to our COVID page because it's there. But if you don't have our latest template questionnaire, you can get that delivered to you. And you know what? We'll make sure that that's delivered when we provide the slides to everyone after today. I want to make sure you're all thinking about questions and interview. When you interview this worker with an eye on where they may have contracted the illness outside of work. It's that simple. Since everybody's talking about vaccines, and in light of what the EEOC issued yesterday, we wouldn't be doing our jobs today if we didn't at least touch on vaccines. I don't want to go through, there's a lot of detail here, but I think it's pretty, I think it's kind of simple. Now, whether or not you mandate it or not, that's not a simple issue, and that's a question that you all have to come to terms with, depending on your industry, depending on your geography, what your workers do day to day, whether they're healthcare workers or not healthcare workers. It's something for you all to be talking, and you should be having that conversation with your labor and employment counsel and other corporate counsel related to this issue of vaccines. But it's a potential, if you are mandating it, there is potential for work comp based on a bad reaction or allergic reaction. We don't know all of the, how it may impact a particular individual. I want to highlight that yesterday the EEOC issued their guidance and basically said didn't preclude employers from requiring the vaccine. It just said if you are going to require it, you need to show that an unvaccinated employee would pose a direct threat due to a significant risk of substantial harm to the health or safety of them or others that cannot be eliminated or reduced by reasonable accommodation. Now, we know COVID-19 does pose a serious direct threat to this health and safety of human beings. I think that's I'm pretty confident in that conclusion and drawing that conclusion. What I think the emphasis, based on my read of the EEOC guidance, is that if you're gonna mandate the vaccine, you've got to ask yourself: is this individual, what they're doing, where they're doing it, who they're interacting with? Do they have to have the vaccine in order to do the job or to prevent a risk to themselves or others? If they're in a bunker by themselves, 500 feet below Mother Earth, and they're not interacting with anyone else, I don't know why we would require them to have the vaccine. I think that's what the EEOC is trying to get at. Also, you need to understand that there's exemptions with a mandatory vaccine, religious exemption, and a disability ADA exemption. So you need to keep that in mind, and then that would trigger, if an exemption would apply, it's an undue burden analysis. That burden is on the employer. It's a bit lower to deny a religious exemption for employees. That burden is a bit lower for employers, easier for employers to deny a religious exemption than a medical disability exemption from a vaccine mandate. Alternatives, encourage it. You can encourage it. You certainly can make it easy, affordable. Though the vaccine should be without cost, but you never know what the future holds. Allow paid time off to get it. Similar to probably what you're doing with the flu vaccine over the years. Some common sense initiatives that, again, with the eye on the reducing litigation risk and work comp claims, the PPE, the masks, the face shields, the social distancing, the temp screenings, the daily health checks, flexible attendance call-off rules, sanitation, diminish that herd on site, the remote worker, stagger shifts. Some other, I'm kind of going through a potpourri of of different topics now, but for those that are in union environments or with a labor organization, vaccination is likely a subject of mandatory bargaining, especially if it's a requirement of the job to continue employment and be scheduled. Changes in policies that could result in disciplinary action is likely mandatory subject of bargaining. Double check your collective bargaining agreement and look at your management rights clauses. Even if you have the right to implement new policies that could result in disciplinary action under a management rights clause, consulting with the union, giving them a FYI, a heads up, would certainly foster goodwill. If non-union employees protest COVID protocols, remember that's protected activity, and understand that labor organizations, good, bad, or otherwise, are licking their chops and using COVID-19 as the way to organize workforces. Something else to consider, and I'm not going to read this, but document, if you are going to encourage or mandate vaccines now or in the future, I would consider documenting somebody declining it, where and when it's appropriate. I think that this, it would not absolve you if they contract COVID-19 in the workplace, but I think it certainly would go a long way to kind of give you a little bit of cover in certain circumstances and situations. Understand that the CDC, again, with an eye on keeping up to date with the latest and greatest. You remember the CDC revised their close contact for exposures. And that 15 minutes is cumulative over a course of a 24-hour period. And the CDC also recently updated the quarantine rules for asymptomatic individuals, going from a 7-day and even a 10-day option, assuming that there are no symptoms. So I wanted to run by those quickly and throw it back to Jack. Jack, if you could just spend a couple minutes maybe just identifying the Walmart case and just kind of generally what it all means for employers.
So this is the first COVID case that was filed in Illinois, and it's going to probably look like cases that are popping up all over the country. It was and the lawsuit was filed by someone who unfortunately died from COVID, brought suit against Walmart and the employer for the deaths of the Walmart employee. One of the things that we mentioned earlier was that plaintiff lawyers are going to get creative, looking for deep pockets and things like that. And this is a good example of it, where the lawyers are going after not only the employer, but they're going after the landlord, which probably had nothing to do with the day-to-day operations of Walmart. But that's what you see. The allegations included things you would expect: failing to sterilize, failing to promote and enforce social distancing, failing to basically adhere to the CDC, Department of Labor, and OSHA guidelines at the time, and specifically failing to isolate sick employees from other ones, which is a crucial issue in this case. The case is still pending in Cook County. We don't really have an update on what's happening on that, but it's something we're tracking closely. One of the things that employers should be careful about, however, is liability to non-employees based on the exposure that happened to the employee. So, for example, an employee gets COVID-19 and assume that they can prove it and everything else. Well, that's gonna be a comp claim, right? That's gonna be a workers' compensation claim. But the employee then goes home and gets his wife and kids sick. Can the wife and kids sue the employer in a civil lawsuit? And the short answer is maybe. The longer answer would take up the rest of our time here. But in a situation like that, it may be the case that the employee may be liable not only for the comp claim for their sick employee, but also for whatever happens to the folks that employee then spreads after the fact, which is one of the things that we have expected to see pop up in more litigation, and maybe we will. But luckily, I don't think that we have seen a lot of that right now. So one of the things you're gonna have the same questions you would otherwise, which is going to be proving causation. How do you prove that this employee is the one that gave it to the person outside of the workplace, and things like that. But it is something that we are keeping an eye on, and something that that businesses and employers should be cognizant of.
Yeah, I mean, Jack, I think the best. The best defense is an offense, and going on the offensive when an employee does unfortunately get COVID, to really try and isolate facts and shore up facts that they very well could have gotten it elsewhere. And I think that's key, especially with the third party claims and causation. So I don't know if you wanted to, Jack, if you wanted to conclude with with some absolutes here.
Yeah. At the end of the day, the things that it's just like Jeff has been saying. The best thing you can do is strictly adhere to the rules as they come out, and frequently update whatever compliance efforts you're making, because the rules are constantly changing, right? We've seen over the past 9 months how the government agencies, state and local agencies, are constantly updating what has to happen in the workplace. So that's that's going to be put on the employer to not only, as we sit here now in December of 2020, if the workplace is complying with orders and recommendations that were put out in May of 2020, well, they're probably out of compliance for what's happening right now. So these absolutes that we're talking about is make sure that you are constantly updating, reading the fine print on the orders and recommendations that are being published. Same thing goes with CDC and OSHA guidelines, and make sure that you have written documents that document and record your compliance with the implementation of safety first policies.
Thanks, Jack. And on that, some other considerations from an employment lens is, I think it's important to always check your local state paid sick leave mandates, making sure you're complying with employee leave mandates. Of course, the ADA and the FMLA doesn't go away. And make sure that we're exhausting when we can, where we can, FMLA to the extent that FMLA leave may be applicable, particularly if somebody does contract COVID and it leads to, quote unquote, a serious medical condition pursuant to, as that term is defined under the Family Medical Leave Act. Not all COVID cases, or certainly not exposure to COVID, would require FMLA entitlement or ADA considerations, but it is a slippery slope. It's a very thin line between non-ADA, non-FMLA considerations and ADA, FMLA considerations related to COVID. It's very fact sensitive. Look at your attendance. If you have not modified or done something or implement a COVID specific attendance policy, even some written communication, if you don't feel good, stay home. I think you're kind of behind that 8 ball. And you need to reconsider your attendance policies and do it carefully if you haven't already done that. And in fact, I was just talking to a client yesterday that they're amending their attendance policy for like the 4th time since this whole thing started. That's good. I don't think anything can stay stagnant too long with what's going on in the world. Documents to consider. If you're doing health checks, make sure you've got the screener forms, confidentiality forms and procedures. Make sure that what are you communicating to employees who are just afraid to come to work? Employee questionnaire. If somebody does contract COVID-19 and they happen to work for you, and then, what are we communicating to employees that have had no close contact, as that is now redefined under CDC guidance, and letter to employees or individuals with close contact. I think these are essential documents and tools. If you don't have these essential documents and tools, reach out to us. We have them and we're happy to give those away. No questions asked. Speaking of which, I think the most fundamental piece to trying to protect yourselves as employers is the questionnaire. And this is not a static questionnaire. This evolves. It's something for you to consider. This is not something that the employee fills out. This is something that an experienced manager fills out, safety manager or HR. And it's that real-time information on circumstances surrounding what may have happened. And I'm not going to read it word for word. I think a lot of it is self-explanatory, but you see where it's going, right? You see where it's going. Where have you been in the last 30 days? What have you been up to? Have you traveled? Where have you been? I think these are legitimate questions. I think these are legal questions. And certainly the inquiries are there specifically to try and figure out what they've been doing. This last one, outside of work, what have you done? Where have you been? And that's something that HR or safety can look at and develop. You probably want to look at this and develop something that works for you, that's more tailored and customized to your workforce, your geographic reach, where you're located. And then accompanying this is this HR checklist that sort of accompanies this questionnaire. I think in real time, kind of covering your rear end, employers, and looking at other sources, the social media accounts. Did you do and follow contact tracing? Did you disinfect? Have you implemented CDC and OSHA guidelines? Have you implemented the latest guidelines on a local or state basis? Of course, the answers to this, right, should be yes, not no. And this is another document and a layer of, I think it helps employers to kind of focus on what's really important with this. So I know that's a lot to unravel and unpack, and so we went beyond work comp. But I think the general bottom line is implementing what you need to implement with the guidance and the mandates on the local, state, and federal level, paying attention specifically to what your local and state Department of Public Health is saying and recommending, unique perhaps to your geographic area, your footprint, your geographic footprint, your industry. And then also keeping in mind the CDC and OSHA guidelines, creating that COVID-19 plan, training on the plan, changing the plan, do not be stagnant. And ultimately, if there is some sort of, when you have the worker test positive and is positive for COVID, there is a logical explanation. I want my clients, Jack, to be, there is no way this person got COVID at work. There's no way. I mean, it may have, but it's not likely because of all the things that we've done to ensure that it wasn't spread or transmitted in the workplace. And here's the evidence. Here are the facts.
Ultimately, your question is probabilities. Because no one's going to be watching someone as they contract the illness. It doesn't happen in a specific split second the way that someone who gets a knee injury or something like that, you see it, when it happened. It's all about ruling out possibilities and keeping that probability down so low that no one can plausibly say that it happened in the workplace.
Yep, a good point. And with that, we're going to end this. Jack, awesome job. Thanks for helping me out. And everybody be safe and have a wonderful holiday season. And again, if you need anything, let us know. Be assured that we will get the slides and we will get that questionnaire out to all attendees in the coming days. And we will have your answers to your questions answered quickly. Thanks, everyone.